Welcome to Business Legal Lifecycle TV, the live TV show all about the legal aspects of your business to help educate you on complex legal terms in an easy to understand manner, to help understand why you need to do certain things in your business from a legal point of view, and to help you develop a plan for the future. Our mission at Business Legal Lifecycle is to help empower all small to medium-sized businesses around the world to get access to legal advice so that they can help build their communities and make the world a better place. Did you know that any business owner is on average 7 months away from losing everything? That is the average time it takes from a successful business to fold when an aspect of their business is not set up correctly. Have you ever wanted to get legal advice but didn't understand what was going on? Do you feel like there is a divide between lawyers and their clients? Then this TV show is for you. It is all about empowering you and your business with the knowledge and tools to ensure that this doesn't happen to you. Business Legal Lifecycle TV delivers a twice-weekly show focusing on the legal aspects of your business. At lunchtime on Mondays, we present Fast Fix Monday, a quick 5 to 10 minute show that will give you some actionable steps to consider for the week for your business. And at lunchtime on Wednesdays, we present our in-depth show of between 30 minutes and an hour, where we go through complicated legal aspects of your business in a simple to understand, plain English manner. And whether that is through educational pieces or interviews with experts in their fields.
Afternoon everyone, and welcome to Business Legal Lifecycle TV. Today is Wednesday, so it's one of our longer form education shows. We're expanding a bit more on litigation and dispute resolution, which is phase 10. As always, I'm Craig Mason, one of the founders of the Business Legal Lifecycle, and I have with me Jeremy Stretton, the other founder. Say hello to everyone, Jeremy.
Hey everyone, I hope you're having a great day.
Excellent. So as I said, we're into phase 10. We spoke about it on Monday's Fast Fix Monday, and we're expanding on it more today. But Jeremy, do you want to explain a little bit more about phase 10, litigation and dispute resolution?
Yeah, so as we went through on the Monday show, phase 10 is, as Craig said, all about litigation and dispute resolution. And you'll see here, if you're watching this on the Facebook Live, YouTube, or Periscope, we have the Business Legal Lifecycle, and phase 10 comes just before sale of business, which is phase 11. And the reason for phase 10 being here is that it really, at some point in your business, unfortunately, there's going to be some sort of litigation. And we wanted to acknowledge that and say that if you hadn't got there by this stage, then really, litigation will happen to occur. Now, this could be for any reason. I went through on Monday all the different reasons that litigation could occur, but you just need to be mindful that it does occur, it can occur, and it's not unusual for it to occur. It's very normal in business for that to happen. So litigation and dispute resolution is phase 10. Craig, do you want to start off going through this phase?
Yeah, absolutely. So the first slide, if you're watching it, is commercial litigation. So as Jeremy said, when you're getting to this phase in your business, unfortunately, things like litigation tends to pop up. And obviously, all litigation matters are a last resort where you can try to avoid these. And there's other ways that Jeremy will go into further today about other ways of avoiding necessarily court proceedings via alternative dispute matters. But when we're talking about commercial litigation, we're talking about where we're heading off to court normally. So there's several statistics out there about what sort of happens and what ends up in court and those sorts of things. The statistics that we have is that only about less than 1% of all business disputes will start actually in court, and of those, only 1% will actually ever reach a trial where it's decided by a judge or a magistrate, depending on what court you're in or what state you're in. So obviously, not many matters actually get to court, and then not many matters after that actually go the full way. So it is a pretty serious thing to do, and as I said, it definitely is a last resort. We're going to go through today the sort of process that most matters will go along in terms of a court litigation matter, and then also I'm going to talk about some debt collection techniques leading up to that to hopefully avoid some litigation matters as well if you have those things in place. So moving right along, Jeremy, the next slide is the process. So as you can imagine, if you've ever been involved in any litigation or you've heard stories about it, it can be a long process. and can be quite a costly process. There's many different steps, different courts and different meetings. Again, you need to work out exactly what the actual matter is as to where you're going to commence. So certain courts have different monetary jurisdictions. So for instance, in Queensland, the Magistrates Court is up to 150,000, and then above that you go to the District Court, and then above the District Court monetary jurisdiction you're in the Supreme Court. But within that as well, different courts deal with different types of matters. For example, the Queensland Magistrates Court does not have the power in an injunction application, whereas the Supreme Court has the power to make broad decisions and orders in many different areas. So you need to be, and you'll be seeking the advice about where you're going to actually commence proceedings. It's important to commence in the right place, obviously. You don't want to commence somewhere and then it's the wrong jurisdiction and you're getting struck out and having to go off somewhere else. So it's important to get that right when you're commencing proceedings. As always, you'll be seeking the advice of your advisors in this regard, and don't go off and just do it yourself. So once proceedings are filed, so you've picked where it needs to be and the proceedings are filed, depending on the court, a document will then be sealed by the court, and that's your originating proceeding. So it might be a claimant statement of claim or an application or whatever it might be in the particular court, but that's the first document that's filed by the plaintiff or the applicant in the particular matter. Ordinarily, that is then served on the other party. So depending on what it is, it might need to be served personally, it might be served on your registered office, or it might be served on a particular solicitor or legal representative that's acting. So these are the sorts of things, you're instituting these proceedings, but potentially you need to be aware of these sorts of things happening in reverse to you as well. So your registered office is important to keep up to date. You don't want to, sort of rely on other people to update your registered office. If there is a change, make sure that it's updated with ASIC, because your registered office, when it comes to court proceedings, can be a very important address. The amount of clients that we see that haven't had their address updated, all these documents have been sent there, they're unaware of what's going on, and all of a sudden they're getting court judgments or various other things against them without their knowledge. So it's very important to keep your registered office up to date, because a lot of documents will get sent there. Depending on the court, again, there'll be a time frame in which the defendant or the respondent needs to file what's normally called a defence or some form of response. That's also the time if there's any counterclaims. So if you're suing someone and they say that you owe them money or that there's damages flowing to them, then they'll file what's called a counterclaim at that stage as well. Normally the time frame is somewhere between 21 and 28 days, depending on the court. And again, they're important time frames that you need to make sure that things have been filed within time, because if you're not, then you can come into some trouble. And that trouble is normally what's called a default judgment or a default order. And that's where you file proceedings, someone hasn't responded within the time period, and the court basically says, okay, well, they've essentially admitted everything, and they'll give you default judgment for whatever amount it is that you're seeking. Or if it's damages, then there might need to be an affidavit of damages filed that particularises the actual damages that you suffered. But then you'll get a shiny piece of paper with a court seal on it that says that Joe Bloggs or Billy Bob or whoever it might be owes you a certain amount of money. So you've got a piece of paper, and then you need to do things via enforcement with that. If a defence was filed, however, it was hopeless or had no real triable issues within it, then you can also ask the court to order what's called summary judgment. That's where you're basically saying to the court, a defence has been filed, but it's essentially bogus and has got no chances of successfully defending the matter. A court, if they're convinced of that, will then say, all right, well, I don't think it should go further after today, and they'll give judgment in that regard as well. So again, seeking advice about those sorts of things. If there is a defence filed and it does have merit, then the matter will continue on from there. There'll be a reply to the defence filed. There'll be an answer to any counterclaims. Going to be making a decision based on the evidence presented during the process.
No, I think you covered it well.
Okay, excellent. Thank you. Alrighty. So that's the process. We just want to pay it up front or paid in cash for a particular good or service that you're providing. Then debt collection or the debt collection process becomes relevant, and you need to have one in place. You want, normally sort of one person responsible for that, or a team of people, but not sort of random people all over the business responsible for the process. So generally, the process that we recommend is, obviously step one will be doing an invoice. However you might do it, you're issuing an actual invoice to the customer. That'll have on there your terms of payment, 7 days, 14 days, 30 days from the end of the month, whatever it might be. But that will be on your tax invoice. Obviously, you want to make it easy for someone to pay. So there's plenty of things out there at the moment with, ease of payment, easy debit, whatever it might be. But look into that further. You want to make sure, or make it easier, that the person can just click on one button and it gets paid. So credit card payments, those sorts of things you want to try to accept rather than the old checks and things like that. So that'll go on the invoice. Then the next step is, if payment's not made within your particular terms, whatever they might be, you then have a process where that is followed up. We normally suggest, the next day as a follow-up. And this is a friendly type email, or that basically says, oversights might happen, just referring to that invoice, etc., etc. And that's, sort of taking into account that some people mightn't have received the invoice, or they saw it and they sent it off to their accounts department or whatever it might be. But it's important to have a sort of friendly approach at step 2. Step 3, we suggest that, waiting another sort of seven odd days, depending on your terms, and that the next step should be a telephone call to contact the business to have a discussion about why the invoice hasn't been paid, etc., etc. And, you'll be given reasons as to why it hasn't been paid, or it's in the next payment run, or whatever it might be. It's important at that stage to take those notes and make sure you're documenting all of your attempts. And then step 4 is when all of those have been exhausted and it still hasn't been paid. Then you're considering sending a legal demand that basically says, if you don't pay within a certain period of time, we're going to be referring it to our lawyers or our debt collection agency to take the next steps, and from there costs will apply, interest will accrue, those sorts of things. So you take that final step, and then we suggest that if you've done that part, then that's where you do refer it off to your debt collection agency or the law firm that you're dealing with. Don't have any further contact with them at that stage, the business. Hand it over to your debt collection agency. So debt collection agencies, obviously that's what they do. They go out there and collect debt on your behalf. They have a process they follow. It's important to speak to your debt collector, your debt collection agency, make sure you're comfortable with them. If you have any questions about debt collection and debt collection agencies, please let us know and we can point you in the right direction. Most debt collection agencies will charge on a commission success rate. So it's important to find the right one. And if you've got something in your terms and conditions, depending on where you are, what jurisdiction, you may be able to recover from the business that hasn't paid you your debt collection fees that you've had to fork out as well in terms of the percentage. So important to get the right debt collection agency. Before that, within your business, extremely important to have a debt collection process in place. So you then can hand over the file to the debt collection agency in a efficient and well organised manner, and you've got all the notes of the conversations you've been having. So generally, that's debt collection summarised. If you want to kick over to reviewing contracts.
Yeah, definitely. So reviewing contracts is an interesting one because it's something that a lot of people miss out on, but it's something that we think is pretty important. So when you get into phase 10, and if you remember the graphic that I showed you, or if you listen to the podcast, go into businesslegallifecycle.com/097. This is our 97th show. And you can see a copy of the Business Legal Lifecycle there. But when you've been in business for any period of time, the contracts that you've engaged with your clients and also the ones that you've engaged with your suppliers need to be reviewed. And it's something that most people don't do. They just think, oh, we'll just keep on going through and just the way that we're going, it will be fine. But this is really important at this stage to actually review the contracts to make sure that the terms of them are actually what you're after. And often you'll find, in fact, 99 times out of 100, you'll find that you'll want to change some of the terms, that maybe the way that they've been working hasn't worked exactly how you envisaged it from the beginning. Maybe it isn't working from how the other side actually thought it was going to work. And now's the time to actually go through and actually review your contracts. Now, this doesn't mean that you have to stop everything that you're doing straight away and engage lawyers to review all of your documents and all of your contracts. You need to take a measured approach, do it over a period of time, and seek advice where you're not sure of something. You might find that a term of one of your contracts just isn't working for you. Well, this is the time to actually review them and change them. Now, ideally, and in an ideal world, you do that on a yearly basis. But look, let's face it. Craig and I are business owners too. We know that most people don't have time to do it. So you need to set aside some time to actually do it. It doesn't have to be done yearly. It would be if you could, but if you can't, then just do it whenever you think you need to, and probably every couple of years at least for your main contracts, because your business will evolve, and your business mastery will also change. So you'll need to check all those things out. Now, the advantage for your business of actually doing this is that most people don't do it. So you'll be ahead of the curve for most businesses in most industries. Most businesses just keep on puddling along with their contracts until they have a problem. If you're reviewing them at this phase of your business, then you'll be ahead of that curve and you'll be able to make sure that you're getting things done properly and staying ahead of them. One of the other things that I find quite amazing is the amount of business owners who don't actually read their contracts. Make sure that you've read them, because if you don't, and you've signed them, then guess what? You're bound by what they say. So reviewing contracts, if you haven't done it before, it's a good time to do that in phase 10, just to make sure that you're completely covered. So that's reviewing contracts. And as Craig alluded to earlier, I'm going to talk about some forms of alternative dispute resolution. And as Craig said back right at the beginning, most commercial disputes don't go to court. And of the ones that go to court, most of them are resolved by other means. And the reason for that is that going to court is a costly exercise, and that the courts have recognised, and the governments around Australia and the world have recognised, that it's far too expensive to expect every single dispute to go to court. Expensive not only from the point of view as the business owner of trying to get the dispute resolved with lawyers, but also the cost to the government, because they've got to employ judges, they've got to build buildings, they've got to they've got to build a lot of stuff and have a lot of infrastructure in place for disputes to be resolved. So they are very big on alternative dispute resolution. And you'll see that I've got that slide up at the moment. And there are different forms of alternative dispute resolution that I'm going to talk about today. There's mediation, and then there's conciliation and arbitration. And I wanted to go through these because it's very important to understand that these are very important, but also very cost-effective ways of resolving a dispute. Remember that the principle of the thing only makes lawyers rich. And so you need to make sure that you've actually got a process in place to actually resolve your disputes without going through the massively costly and process of court. The other reason to be wary of going to court is the time that it takes you out of your business and the cost emotionally that going to court can take on you. Most people don't realize just the time and the effort that it will take them out, take you out of doing your business, and that why you might not be able to go to court, and why it might not be a good idea for you and for your business. So cost isn't just the only reason, it's the mental anguish that going through court can occur to some people. So I'm going to go through mediation first, and then I'm going to go through conciliation and arbitration, because they're very similar. Mediation is probably the most well-known and often used of the alternative dispute resolution methods. It is the process in which an independent third party, usually called a mediator, will assist the people in a dispute to identify the issues in dispute, develop options to try and resolve the dispute, consider other options to resolve the dispute that people may not have thought about, and try to reach an agreement. And that's really important to understand, that there are other ways to resolve disputes other than just money being paid. If you go to court and if you go through a litigation process, usually a court can make one of a number of decisions that usually involve the payment of money or the sale up of property or quite limited scope of things that can actually be ordered. Mediation gives the ability for other remedies to be agreed to by the parties that a mediation might not be able that a court process may not allow to occur. So using mediation can give you that process. So the mediation process, there's no real mandated process for mediation. But generally, a mediator, and a good mediator, will have their own structure. So different mediators for different courts and different disputes. You can have people whose whole job and whole business model is being a mediator. You can have court-appointed mediators. So in Queensland, where Craig and I are from, we have the Magistrates Court, as we've alluded to a number of times, and they actually have a registrar who actually conducts the mediations. You can also have barristers and other people who can act as mediators. But they'll have their own structure. Often that will be that they'll have the parties sit in a room and tell each other their side of the dispute, which the parties probably already know, but it's good to just each party to hear that. Then the mediator might ask some questions, and then usually they'll send them off to different rooms to go and have a chat about what can actually be resolved. So the role of the mediator is to explain the process, to make sure everyone's there voluntarily and that they understand what they're there to actually resolve. They'll also keep the parties focused and try and get rid of any extraneous issues that might cloud the process. So often people in dispute, quite rightly, they'll be emotional and they'll want to raise all sorts of issues. A good mediator will be able to keep those issues really narrow and make sure that people can really see really what we're talking about. And that way they can help identify issues that may not have been previously raised. A good mediator, especially when you're using a barrister, will often be able to give some legal opinion on the dispute and might be able to show where one party may be wrong or show the weaknesses in different parties' cases. A good mediator will also, if they can't resolve the dispute, clarify the issues and provide the opinions, as I said before. And then they might be able to suggest alternatives. So they might be able to suggest alternatives that a court can't suggest and the parties haven't actually thought of. A mediator will never take sides. And that's really important to understand. And it's something that a lot of people in mediations, Craig and I have done a lot of mediations over the years, and often a mediator will come in and they'll talk about the issue and they'll tell a side all about how that's, that they're in the wrong and that the other side is right. They're only really doing that to show the weakness in your case. And what you need to understand is that same mediator will be in the other room telling the other side all the weaknesses in their case. So you need to really make sure that you're getting a good understanding of what the mediator is doing and what their role is so that you're not misunderstanding. So how can you use mediation? So long as the parties to the dispute feel comfortable in resolving the dispute and are willing to let a third party get involved, then they can go through the mediation process. Many disputes are resolved using this process as it is a fair and reasonable way to come to a resolution that is a lot cheaper than going to court. If you don't have an intention of resolving the dispute and you think you're 100% right and the other side are never going to be able to do anything except do exactly what you want, then you probably don't need to bother going through a mediation process. There's probably no point. You need to be giving some ground. Remember that when you go to court, and we'll talk about this a lot this month, when you go to court, a judge will look at the dispute and they'll look at your side, they'll look at the other side's side, and they'll decide that the decision and what's right is somewhere in the middle. That might be closer to you, it might be closer to them, who knows? But in mediation, you've actually got control over that dispute. So usually a lawyer will be able to attend mediation and make sure that you're properly represented and come up with a resolution that's fair and reasonable. Craig, before I move on to conciliation and arbitration, is there anything you wanted to add?
Yeah, just one thing to bear in mind when you're looking at reviewing contracts and when we're talking about alternative dispute resolution, that a lot of contracts have in there a process that needs to be followed in relation to disputes as well. And some of those will include mediation. So it's important to be aware of those when you're reviewing your contracts and when you're entering into agreements as to exactly what you need to follow and don't go down the wrong path in breach of your agreement. So something to definitely look at when you're reviewing contracts and when you're looking at alternative dispute resolution to make sure you're following that process. So yeah, that's all I have. Jeremy, if you want to keep going.
Yeah. And that's a good point too for conciliation and arbitration. Often a contract will prescribe a conciliation or arbitration process, won't it? So you need to be careful of that.
Mm-hmm. Yeah, absolutely.
All right, so let's get on to the last topic, which is conciliation and arbitration. So this is the process, and conciliation, it's a similar process to mediation, except that the conciliator will usually have a professional expertise in the subject matter of the dispute. So generally, they'll provide both legal and practical advice to help identify the issues and resolve the dispute. They will usually not make a judgment, but their job is to help guide the parties to the resolution. As I said, the process is similar to mediation, except we're discussing the issues with each party. The conciliator can provide their expert knowledge. So this might be in relation to some sort of building dispute. You might get a conciliator who's got some sort of building expertise. Again, they will not take sides, but they will not tell you what decision to make, but they will help to show you both sides of the argument in your dispute so that you can resolve it. Arbitration is similar, but it's more like an actual court process. The arbitration, in an arbitration, the parties present arguments and evidence to an independent third party, the arbitrator, who is empowered to make a determination. It is useful where there is a dispute about a matter that is highly technical or where confidentiality is required, that the arbitrator can actually follow that process. So as I said, this is a much more formal and structured process than mediation and conciliation. Usually arguments are made and then an arbitrator makes a determination that both parties have previously agreed will be binding on them. The fact and understanding that whatever decision an arbitrator will make is binding is really crucial to the process, because there's no point in going through that process if you're then just not going to go through and accept their process, their party. So if one party loses and will not abide by the decision, then the process is a complete waste of time. As with anything, as with court processes, there's usually an appeal process, but you need to show that there's some sort of bias or that the decision was unfair or unreasonable. So that is the conciliation on arbitration processes. They can be very useful processes that people can use. Craig, did you want to add anything to the end of conciliation and arbitration?
No, I don't think so, Jeremy. That's covered well.
Excellent.
That's
Yep, cool. So thank you everyone for joining us. This was our education show on phase 10. As I said earlier, it is show 97. So if you're looking for the show notes, businesslegallifecycle.com/097. Craig, anything else you want to add?
No, I don't think so. Remember to like us on Facebook, or like the video so you can follow any comments that might be made. As we said, this process can be costly and can be a long, drawn-out process, but not getting the right advice at the beginning makes it even more costly and more drawn-out. So make sure you're getting the advice. We'll be back again on Friday for our legal updater, our monthly legal updater, and this month is a special one. We're talking about in Australia. Recently, the federal government handed down their most recent budget. We have some guest stars on our show this week to talk a bit more about the budget and how that's going to affect people going forward. So please join us then. As always, thanks for joining us, and we'll see you again next time.
See you next time.